All right, we're back. This is Senate Health and Welfare. We are back and we're looking at not a new draft, but the same draft for S-215. Kiki, just remind us what is in the three squares bill, and then we'll hear some testimony.
Katie or Kiki?
Katie, did I say Kiki?
I also go by Katie and stuff.
You know, at the end.
Kiki could probably do it.
I should probably could.
She's so understood.
Katie Maitland, Office of Legislative Counsel. So if you remember, this was your bill on Three Squares, Vermont. The first section of the bill deals with the restaurant meals program. This first section changes Vermont's participation in the SNAP program from a may to a shall, because it seemed like there was some lack of continuity in requiring Vermont to participate in the restaurant meals program while having voluntary participation in SNAP itself. So that is why that change was made in the first section. The restaurant meals program would require the state to participate in the restaurant meals program. This program would be administered by AHS in consultation with the Agency of Commerce and Community Development. To remind you what the restaurant meals program is, it would allow certain individuals who have certain qualifications, for example, age or not having access to housing, to be able to use a SNAP benefit in a restaurant to buy a prepared meal. In subsection B, there's language that restaurant participation in the program would be voluntary. AHS, in consultation with the Agency of Commerce and Community Development, shall develop and publish on its website a list of eligibility criteria for restaurant participation in the program, including that participating restaurants have to be licensed. And the eligibility criteria shall advance the following goals: that locally produced foods are widely available to program clients. Restaurant serving foods that represent diverse cultural traditions participate in the program. And that participating restaurants are located in geographically diverse regions of the state. The agency in consultation, AHS in consultation with ACCD shall provide technical assistance to those restaurants applying to and participating in the program. And then section 3 creates a program to have a new position to support the restaurants participating in the program. So in fiscal year 25, one new permanent classified position. The restaurant meals program navigator is authorized within AHS. And then there is a $85,000 appropriation from the general fund to AHS to support this new position. The position would provide technical assistance to restaurants applying to and participating in the program. So that is one topic in the bill, the restaurant meals program. Then we're sort of transitioning to a different topic, which is in the existing Three Squares program. That's Vermont's version of SNAP. Currently, the food plan that is utilized for the calculation of benefits is the Thrifty Food Plan. And this this language requests a transition plan from DCF to look at what it would take to move from the Thrifty Food Plan to a higher benefit that would be based on the Moderate Food Plan. The federal government would not, they would not reimburse for that additional higher level benefit. So that would be a state either additional benefit or a supplemental benefit. But this language asks the department to look at what it would take financially, but also pragmatically to make that switch in the food plan that's used for individuals who are receiving a Three Squares benefit. So the language itself is that by January of this coming year, DCF is to submit a transition plan to the appropriations committees and policy committees, detailing the processes and resources necessary to calculate the minimum benefit for Three Squares Vermont participants at 30% of the USDA's moderate cost food plan, including the nature, cost, and timeline of any information technology changes needed to implement the new benefit calculation. The annual cost of implementing the increased 3 squares benefit. The number and type of additional staff positions necessary to implement the new benefit calculation. And any statutory changes or federal approvals necessary to implement the new benefit calculation. And then the whole bill takes effect July 1.
Just curiosity, can you go up just to here to the 30, right there? What relevance is the 30% of US Department of Agriculture's moderate? If the intent was to go from low cost to moderate cost, what does the 30% have to do with that? Is that 30% of the jump to a moderate plan? Cost one?
I feel like this is a better question for DCF. I believe that right now it's the current benefit is 30% of the thrifty food plan. So this would be consistent that it would be 30% of a higher level plan. Don't quote me on that. But I feel like the witnesses you'll hear from will have a better sense of that.
Okay, that's very nice. Thank you.
Okay, so questions for Katie on this again. We've been through it a couple times and we did hear testimony previously from folks on the bill. So we can go to Peggy Dubois. I say my properly. There you are.
Yes. Good morning,
Well,
Senator. Thank you. Can you hear me okay?
Yes.
Wonderful. Thank you, Chair Lyons, and thank you, Senators. Before I dive in, I actually just want to answer the question that I think Senator Weeks posed. Legislative Council is correct. Currently, it's 30% of the thrifty food plan. So this would change it to 30% of the moderate cost plan because households are expected to contribute 30% of their budget towards their 3 squares allotment. So it's just keeping the same standard. Just wanted to clarify that. Leg Council's explanation was absolutely correct. But diving into my testimony, thank you so much for allowing me to speak today on S215. My name is Hayden DuBois. I'm a visiting fellow at the nonpartisan nonprofit Opportunity Solutions Project. We're a think tank that's dedicated to solving issues on key public policy matters. While I'm not in Vermont anymore, I did live in Vermont most of my life, from Manchester to Middlebury and ultimately living in Montpelier for several years. And so I always appreciate the opportunity to weigh in on important matters such as this one. So I want to touch on both key components of the bill that Legislative Council just walked you through. The first provision relating to the Restaurant Meals Program would allow folks to use their benefits, their EBT cards at restaurants. Now that may sound innocent enough upon first glance, but consider Vermont is one of the more than 40 states that does not allow this currently for good reason. Limiting 3 squares benefits and EBT cards to stores that sell groceries was designed to encourage folks to purchase more affordable food and nutritious options and prepare them at home. I'm sure you may have heard from some restaurants in Vermont who might be interested in the program, but I think it's important to bear in mind that in virtually every one of the half a dozen states that have launched the Restaurant Meals Program, roughly 80% of the participating restaurants are fast food. So in Arizona, for example, Burger King, McDonald's, Subway, and Jack in the Box make up more than 2/3 of participating restaurants. In Michigan, Subway, McDonald's, and Domino's alone account for 75% of participating restaurants. There's a whole host of other fast food chains that are smaller that contribute another portion of that percent. So put simply, the Restaurant Meals Program would run contrary to the goal of 3 squares, which is to provide a balanced, nutritious diet within reach of program enrollees. With Vermont's adult obesity rate of 27% already, I think the last thing that it would need to do is encourage the use of EBT cards at fast food restaurants. Now, the second component of the bill I would think is also concerning. As Legislative Council noted, it would transition Vermont from the thrifty food plan to the moderate cost food plan and have DCF submit a transition plan. Well, what does that mean? Today, the thrifty food plan is the baseline food budget set by the USDA to calculate benefits for 3 squares and every other food stamp program in the country. And food stamp benefits are adjusted every single year to account for changes in the cost of food. Now, the moderate cost plan is an alternative, much more expensive food plan. Not a single state in the country uses it to determine their food stamp benefits. Why? Well, for one, it is 34% more expensive for the average reference family than the Thrifty Food Plan, and as a result would result in, on average, 34% higher benefits. Based on Vermont's food stamp spending for the most recent calendar year, and according to USDA data, we project that would cost approximately $54.3 million per year to transition the state from the Thrifty Food Plan to the moderate cost plan for Three Squares benefits. And as Legislative Counsel already testified, that's going to come 100% out of state funds. Three Squares is traditionally a federally funded program, but there are no federal pathways, no provisions in federal law or federal rules that would allow a state to use federal dollars to pay for this more expensive option. Simply, you'd be blowing a roughly $50 million hole in the general fund because it's going to come out of state funds. I think this is a solution in search of a problem. Over the last 15 years, the average per person Three Squares benefit in Vermont has increased by 75%. Meanwhile, food inflation is up by less than 50% over the same period. So in other words, the Three Squares benefits are already keeping up with and exceeding the inflation rate. So having DCF to construct a transition plan to hike those benefits by another 34% that the state will pick up the tab for would simply be tying up additional funds that could be used for other purposes. And that's not to mention there's nothing to be done about food insecurity in Vermont. I think they're important and worthwhile investments to look at, especially in community organizations like the Vermont Food Bank's base funding request, the Meals on Wheels funding proposal, or the local food incentive grant base appropriation, all of which are currently under review by the Senate Appropriations Committee, each one of which would deliver on the goal of getting nutritious food to hungry Vermonters at a far more affordable price point than an expansion of Three Squares by 34%, which has already ballooned over the past 15 years. So if you take nothing else away from this testimony, these are just the few key facts I want to leave you with. First, in other states that use restaurant meals, roughly 80% of participating restaurants are fast food. Vermont already has an adult obesity rate of 27%. Vermont's average food stamp benefits have risen by 75% over the last 15 years, ahead of inflation. And switching to the moderate cost food plan would raise benefits by 34% and could cost the state more than $50 million each year. For all of these reasons, I would urge you to oppose S215 and instead support the much more prudent and effective proposals to support community food organizations in Vermont that are making meaningful efforts to reduce food insecurity and are currently having their proposals before Senate Appropriations. Thank you so much, and I would be happy to answer any questions.
I do have a question.
Yes.
Can you please provide your testimony if you haven't already? We've got it. Okay, we have it. So it's all good.
Yes.
Is there any redeeming value in 215 from your perspective?
Personally, I don't think so. I think these provisions are they can only lead to either a program with a restaurant meals component that would potentially increase the obesity rate and encourage unhealthy options, and then on the other side could cost the state a significant amount of money. Meanwhile, I really do think it is worthwhile to focus instead on those local community organizations that are doing so much to reduce food insecurity. I think that's where the most effective use of taxpayer dollars are going to get at, rather than an additional hike in the base Three Squares benefit by switching to the moderate cost plan.
Okay, thank you. Questions, committee? No. Okay, we're good.
Okay, thank you so much, Senator.
Wait.
Hey, is Vermont currently a cash-based SNAP state or Three Squares state, meaning that the benefit is delivered in cash versus the credit card format?
You know, that is a great question. I would have to double check with how DCF is administering it. I actually don't know the answer to that off the top of my head, whether they're cash-based or credit card-based. Most states do issue electronic benefit transfer cards, EBT cards. I want to say I was under the impression Vermont does do it that way. Although I could be, oh, here it is. It says right here on DCF's website, you can either get it directly as cash in the bank or on an EBT card that works like a debit card. So it's DCF decides that on a case-by-case basis, apparently.
Okay, other
So,
questions?
so we don't know currently if they can use a, cash benefit card at a fast food place?
In theory, they can't use their EBT cards at a fast food place. However, if they're getting cash benefits deposited in their account, there's obviously a little bit more flexibility on how they could make those purchases. But with the EBT cards, it's more restricted to conventional retailers and grocers, for example.
Other questions? Hayden, thank you very much, for your testimony. And we'll be coming back to 215. Trying to figure out which day. Tomorrow or the next day, 'cause that'll be the end of before crossover, so we'll be trying to look at all the testimony that we've heard and make decisions, so thank you very much for your time.
Thank you, Chair Lyons, and thank you, Senator, so much. Have a great day.
Okay, you too. Okay, so, that kind of interesting testimony, but I would suggest that we have just a few minutes, and Katie, let's go back to, let's think about the testimony that we've heard both from the pro and this is, I'll say it's con. So let's think about that and we'll come back to the bill tomorrow or the next day, find some time, keep the computer in. So Katie, do you have a minute to talk about the potential amendment that we may want to offer on the floor with regard to violence and home health?
Yes. I have a document that has not been edited. We're gonna do that today.
If we can look at it and then if we can decide to hold off until tomorrow, I can ask to have the bill passed over if we have an interest in.
And it's not edited. This is an amendment to S 189. You put a new section 3 in before the effective date section. Which would read. I don't even have a section thing for it yet. Okay, hot off the press, it's still work in progress. If an individual was previously discharged from service by a home health agency to protect the safety of staff in accordance with the rules adopted by the Department of Disabilities, Aging and Independent Living pursuant to section 6303A of this chapter, a home health agency may deny a subsequent admission or decline to send a home health agency employee to make a visit if a home health agency has reason to believe that the individual who exhibited the behavior that resulted in the discharge is present in the home. And then we're renumbering the current section 3 to be section 4.
Okay, questions or comments? Who's making the decision about the behavior?
The agency.
What about the process?
Yeah,
So the,
I mean, we're
They
referring to rules that I have not had a chance to look over, so they're saying in accordance with the rules, so I'm assuming that the rules probably cover how those decisions are made, but again, I got this language half hour ago, so I haven't looked at what is in the rule.
we're not gonna vote on this, you can decide whether you wanna. If my name is on it, but if it's gonna be something that committee members wanna sign on to, that'd be great, if we do it. So. That's what it is, so it's in accordance with rules. So we wanna know that there's due process in the rules. Or are there rules to be drafted about this? So that's, the other option is to ask to have rules. Should we do that, Katie, or is that a non,
I don't
makes sense?
know that you need to do that, I think if
Okay.
they have rules in place that cover this situation about staff safety and that they,
Okay.
you know, there's. So I'm not sure what's the rules. I have to look at the
Okay,
rules, but if
well-
the rules are already covering this, then
So if we passed it the way you just crafted that,
yeah.
wouldn't it go through Elkhart?
Yeah,
Okay,
oh, yeah,
so
very,
they would be the ones that.
no, this wouldn't go
This
through
would
No.
not go through
I'm sorry,
Oh.
no, the rules have already been through
Okay.
Elkhart, so it's what's currently in rules K.
Terry, are you worried about due process for the person who,
It's getting kicked out.
the person at home who is?
Is now been denied home health care because, you know, it might not have been the person, it might have been one of their family members. That's what it's.
I know, but if the healthcare workers feel
Right.
unsafe.
No, and I know it's a catch-22. I support the concept, but. I just wanna make sure that if we can put something in there that provides due process, if we do that.
Or review, correct. So I'll give you a personal innuendo. My mom's, healthcare, home healthcare worker was bitten by the dog, unfortunately. That created a whole scenario. It had nothing to do with my mom, it had to do with the dog. Anyway, it was, if this had happened and the worker felt, uncomfortable, which she did.
Yeah.
There needed to be a way to say, okay, look, we've mitigated the circumstances,
That,
please re-engage, something to that effect.
So what happened, was it your mom's dog?
Yeah.
So, and what happened in that scenario? Did she stop coming?
Initially, yes, but then we found an alternative solution that kept everyone comfortable. Point was, if there's, if it's like one strike and you're out, or that's problem.
The language in the rule is that a home health agency may reduce the designated services being provided to a patient or discharge a patient from services with written notice at least 14 calendar days before the reduction in or discharge from services when one or more of the following happens. I'll just skip ahead. The patient, primary caregiver, or other person in the home has exhibited behavior, including but not limited to physical abuse, sexual harassment, verbal threats or abuse, or threatening behavior that poses a safety risk to agency staff. It says a home health agency may reduce services or discharge a patient immediately and without advance notice if the patient, primary caregiver, or other person in the home has exhibited behavior which presents an imminent risk of harm to agency staff. So that is what this language is complying with.
so this act allows for categorical discharge. They've been previously discharged and deny a subsequent admission or decline sentence.
Yes, so somebody has already
Two
been
strikes.
discharged in accordance with this policy that was adopted by rule. Then what your amendment would do would say, that the home health agency doesn't have to see that person. That doesn't have to subsequently admit that person, or could choose not to send a person. Choose not to have an employee go, where it's thought that the person who exhibited the conduct, the conduct that gave rise to this. So if it's the primary caregiver at the home who's causing the problem, and the agency knows that the primary caregiver will be there, they can say, even though the patient isn't the concern, we know the primary caregiver will be there, so we'll choose not to send our employee.
That was more common. I mean, to me, it seems like a real privilege to get health care, come to your house to take care of you, and to me, it does feel like a privilege, and if you can't make that visit a safe visit, sorry, but that privilege is lost. I mean, is
How
that
can
too
we,
harsh?
how can we say something about ameliorating the conditions that cause the problem? I mean, so in the dog situation or the caregiver, you can't be there, that's something.
If I can address Senator Keeler's point.
Yeah.
Very, very short. It is, but there's also necessity. Some folks just cannot get out. We're talking about, it's,
Extreme.
extreme elderly or disabled, correct, and there's not another option that's not like enormously complicated. That's
If my mom's 95, and I'm her healthcare proxy, and I'm up here, she has a problem there. You know, she doesn't know what to do. It just complicates the problem for her, so.
So,
But if an ambulance shows up, you usually have a team of people,
Right.
whereas could just be one person.
It's typically one person.
it is one person, and we've kind of been through a parallel discussion with DCF workers who are going to a home where there might be concerns. And then they can call public safety and say, come with us, but it would seem to me that'd be the last thing. I mean, that would be the last thing on the list. But there needs to be something in there that can think about. I understand it's a huge problem. And you don't want people to be subject to this at all. My question then is this: shall we pass over 189 and see if we can get to language that we might want to support in an amendment,
So
or not,
for the day.
for the day? Just be one day.
Lost nothing.
Is that something that, do you think we can get to some?
I mean, I have language now, what you saw, I'm not sure what changes you're asking for.
Well, I think we're trying to figure out how to have language that says that the conditions that are causing the violence might be mitigated, ameliorated,
Okay,
eliminated whenever the
so
visit is taking place.
maybe you could have language if the conditions can't be, then
That's-
this is the policy.
That's what I was thinking too, like you
Okay.
can preempt the
Okay.
rest of it. Yeah.
Can we look at that tomorrow then?
Sure.
And then, so I'll ask to pass over 189, and then we can decide tomorrow. Will probably be more toward the end of the day. Let's see. Yeah. We'll put that at the end of the day, Kiki. Discussion on possible amendment to 189. Good, that's good, that's a good. So remind me, Vice Chair, passing over the meeting last week.
Well, we might not have to though, right?
Well, I think we want to see what the language and,
It's up to you, I can show you what I just put together and then we can have it edited after the fact.
well, it's 12 o'clock.
Okay,
So I'm thinking I'd rather have
hold it, okay,
You're on it.
great,
If you have something you could send out to us
sure,
and that.
Send it to everyone?
Kiki and then, yeah, send to everybody.
okay.
That'd be good.
Look here, Jen, for the remainder of the week, are we going to hit 3 squares again? So I don't see it.
We can, I will have Kiki put it on. us.
Yeah.
So we could go off live.